examined the, I guess, spent cartridges and under microscope, and you compared items 2 through 7 with the others to conclude they matched. Is that correct?
Motions that have been filed and that are pending. I think many of them are motions that are appropriate to arise during the course of the trial as witnesses who address them come up. I will point out that there are a number of motions that the defense has filed as it relates to a particular blood spatter expert, that being Tom Bevel. In conversations with the defense, we have agreed that Mr. Murdaugh was confronted the very morning of the murder by his own law firm seeking missing fees. That's the temporal connection of those two events that then tie back to literally a decade of embezzlement. That one question begets another, which begets another. To understand why these are significant, the jury has to understand that he had been stealing for over a decade, 99 counts to date, and facing essentially life without parole on these particular financial accounts, and that's the significance of what he was trying to prevent from being exposed.
His theory, and this is sort of, is that he knew the jig was up, so he went home and blew the head off his son, and butchered his wife. There's not one shred of evidence there was any problems between any of them. There's texts, pictures, people that were with him the previous weekend at a ball game, video from that day with Paul and he having a good time. There is no dispute anywhere that they were the perfect family in terms of their relationships. No divorce, no separated, no left him, no nothing. So this is a fabrication, and they want to use what Mr. Griffin described as bad character evidence. He stole all this money, so he must have killed his wife and son.
That the CMS system will not allow them to create a list, a merged.
And we'd also filed a motion regarding Mr. Kinsey having similar spatter expert opinions, and we had requested a counsel hearing as part of our motion, and what we had agreed to is once we get to that part of the case, if they decide to call Mr. Bevel, then we'd have to have a hearing on Mr. Bevel, and then we'd also, whenever they call Mr. Kinsey, if they intend to offer spatter opinion testimony, we'd need a counsel hearing for that.